is unlimited liability entities, right? Sole proprietorships, general partnerships, and these are the default entities that the law assigns to you if you don't form some alternative business entity with the state, right? So if I go out and start a lemonade stand, I don't start Michael's Lemonade LLC, I'm a sole proprietorship. If you and I go start a lemonade stand and we don't start Michael and Student LLC, Lemonade LLC, the law sees us as a general partnership. And as you'll recall from the lecture, friends don't let friends do business as a sole proprietorship or a general partnership. Reason being that there's unlimited liability, right? These kinds of entities lack the liability protection that quote-unquote good business entities put between the business activities, the business assets, and the owner's assets and the owner's liability. But I'm getting ahead of myself a little bit. I don't think you guys need to know too much about the history of these corporations. I think it's super interesting, but I don't know how interesting it is. It's maybe I've been practicing law too long. It is fairly interesting, but I don't think that knowing the intimate details of the Dutch East India Company is relevant to your future day-to-day lives as businessmen and businesswomen. Therefore, I probably won't put it on the test. But let's dig into the three main characteristics in a little bit more detail. The first one being legal personality, right? So legal personality means that a properly constituted, a properly formed business entity, whether it's an LLC or a corporation or a limited partnership, whatever, is a legal person. It is has not quite the same rights as a human being person, but a lot of them. It can enter contracts. It can sue and get sued. It has certain rights under the Constitution, right? Rights of political speech, rights of due process when it comes to taking away their assets. And these are all well-established rules of law that the Supreme Court has found. So principle number one, modern business entities, legal personality. They are almost human, even though they are essentially fictional. You can't see them, you can't touch them, but they can have a lot of real-world rights and responsibilities that have a lot of real-world consequences. And for the exam, that's going to be something to look for, which is, what kinds of things can these fictional entities do? They can moving on to the second principle, they can sell ownership in themselves to other people, to other owners, new owners, and raise money that way. Of course, they don't have to sell it, right? I can start a company and give all of you guys equity because I'm a nice guy. There would be some tax consequences to that, but there's nothing to keep me from doing that. And I think all of you guys probably understand equity financing sort of intuitively. We all get it. You can go buy a stock. You can go buy stock in Ford, or you can go buy stock in Apple, whatever. One of the things that I hope you guys will know for the final is a little bit about these different kinds of equity financing, right? What are people talking about when they talk about common stock versus preferred stock? More specifically, how could you use that to incentivize different classes of investors, right? If I start a company, somebody comes in and says they want to buy part of my company, but they want certain voting, veto, distribution rights, different kinds of preferences. Can I do that? And the answer is yes, right? Not all owners are created equal. And know the basic difference between what's a public stock and a private stock, a public equity and a private equity, public security and a privately offered security. That, of course, becomes more relevant in the next section on securities, but for these purposes, just know that there's a difference, right? It's a very important difference. I mean, I deal with it a lot in my everyday life, and so maybe I think it's more important than it is, but the fact of the matter is it can have dire consequences in the real world. Okay, so the last of the three main principles of modern business entities is limited liability. This one's probably the one that you are maybe less familiar with coming into the class. Legal personality, fine. You know that Ford Motor Company can own its factory in its own name, not the CEO or any other human being. You get that Ford can sell its shares of its ownership in the form of stock. But what people often don't fully appreciate are the benefits of limited liability. And so it's important as a takeaway from this course, I think, is how exactly this works. And as you know, it limits the value, limits your liability if you're an owner, if you've bought or received this equity from the company, and the company gets in trouble, defaults on a debt, has a slip and fall, poisons a kid, poisons a river, whatever, that company can be sued. Remember, it's a separate legal person, but you are separate. So unless you specifically had something very nasty to do with that, that liability, and even then it's hard to do unless you are directly responsible for that liability of the company. The plaintiffs in a lawsuit can't come after your personal assets, right? So the bank whose loan the company defaulted on can't come after you to get their loan money back. The family of the kid who slips and falls in your store can't come after your personal assets as an owner. And that's true even if you are a single owner, right? This is a weird thing. This is kind of one of the things that people find a little weird. Like, they find it easy to understand, okay, if there are 500 owners, of course, and let's say 5,000 people own Tesla stock, and all the Tesla batteries catch on fire and all these people die, you say, well, but so-and-so was just a silent investor, and he just invested $1 million, and he didn't have anything to do with the design of the battery, Tesla, whatever. So, of course he shouldn't be held liable. So that's a little bit intuitive. What starts to be a little bit counterintuitive, but is actually extremely important and extremely useful in the business world, is this is true even if there's a single member, right, of the LLC, or a single shareholder of the corporation, a single owner, let's say. So, if I open my ice cream shop and I am the sole owner and I form an LLC, Michael's Ice Cream LLC, and I am the only person who owns it. I can be the only person who works in the store, right? No employees. I make the ice cream. Somebody comes into my store and I've left a bunch of melted ice cream on the floor. They slip and fall, and they come after me, and they sue me, and they sue Michael's Ice Cream LLC. They can't come after my personal assets. They can't come after my house, my car, my cows, whatever. They can only go after whatever money's in the LLC's bank account, whatever, the ice cream machine, the building, if I own the building, whatever. And that's a little bit of a weird thing. You think, well, that's crazy, because if Michael hadn't gone down to the Secretary of State and paid $300 to file this completely fictitious thing that only exists on paper, the plaintiffs could come after all the money in his bank account, right? Or his own, his personal assets, his family farm, whatever. But just because he went down to the Secretary of State, and he's responsible, right? I'm the owner of the business. I left the slippery floor there. I own the building, whatever. I did it. But in the eyes of the law, if I have a properly formed, properly maintained limited liability entity, it will be very difficult for the plaintiffs, the parents of the kid who slips and falls, to come after my personal assets. And that is sort of the beauty of limited liability. And I think that's a stronger illustration than one in which you have 10 million different stockholders. It applies even if there's just a single owner. There are exceptions, right? And these exceptions are important. These exceptions will almost certainly show up on the exam. When can you ignore the so-called veil of limited liability? When can you pierce the veil of limited liability? That's a huge area of the law, and it's complicated. But the two big ones are if it's used to commit a fraud. Not so much that the business entity is used to commit a fraud, but that the business entity abuses its limited liability to commit a fraud. So if I run a pyramid scheme and I'm defrauding investors of their money, and then I say, you can't get me because I'm hiding behind this limited liability veil, quote unquote, then the limited liability can be ignored, can be pierced or swept aside. The other biggie is if I treat the limited liability as an extension of me and my business partner's personal human selves, right? If I fail to hold the annual meetings, if I fail to make annual filings, if I basically just go down to the Secretary of State's office, form the LLC, and then never do anything else, and maybe I open a bank account, but I'm using that bank account to pay for my personal groceries. I'm using that bank account to make house payments on my mortgage payments. If I start to do all of these things that paint a picture that the LLC is really not being treated any differently as a separate entity from myself, then the law will say, okay, you want to treat it as an extension of yourself, then we're going to treat it as an extension of yourself, and we're going to ignore that limited liability. And if you, just to kind of carry the hypothetical to its conclusion, if you are doing that and you go out and do business with somebody, and then you try to hide behind the limited liability, we're going to say no. You haven't really treated this as a separate entity, so that person can sue you and come after your personal assets. And that's important. It's not a fail-safe. It's not 100%. It's not 100% effective in all circumstances, so you got to be careful. They're not real human beings, right? They're completely fictional. So real people at some point have to manage the affairs and make the decisions for the entity. And there, you usually have sort of this. Remember the pyramid structure where you have officers at the top doing the day-to-day operations, board of directors that make big picture decisions and don't have authority to make day-to-day decisions, but they have the authority to remove the officers. And then you have the owners at the bottom, where the shareholders or members or whatever, and the owners really don't make day-to-day decisions, typically in a bigger entity, don't make day-to-day decisions, don't make strategic decisions, but they can, remove the board of directors and can have ultimate control over the company on that level. We talked about unlimited liability entities and the fact that they're bad, sole proprietorship, general partnership. So I don't think we need to go over that again. I think that the important thing to notice here is that the law says that you're one of these things unless you go out and form another kind of entity, right? So you can't say, I know that unlimited liability entities like sole proprietorships and general partnerships are bad, so I'm just not going to be one. Well, tough shit, because if you are in business and you do business with people, you are one of these things unless you go out and form an alternative entity like a corporation or an LLC. And then finally, for this section, know the scenarios in which you would want to form a corporation and the scenarios in which you would want to form an LLC. And it basically boils down to attracting investors, taxation, and flexibility. I personally like, and my clients like, LLCs a lot. LLCs are only taxed once. They're considered what's called a pass-through entity. So there's not a tax that comes out at the entity level. The tax comes out at the ownership level. So LLCs are only taxed once at the ownership level. They have a great deal of flexibility in terms of how they're managed. You have a ton of flexibility in how you draft up the documents that govern the management of the entity. And they got a question here I'll get to in a second. Tax flexibility, governance flexibility, and investment, right? Attracting investors. Those are sort of the three things. If you're trying to choose between a corporation and an LLC, you say, okay, what are my priorities, or what are my clients' priorities between these three things? So LLCs are passed through for taxes, great deal of flexibility for management, but sometimes they are difficult to attract investors because the investors, many institutional investors, big investment funds, get totally hosed on taxes if they invest in LLCs. I'll expand on that in a second. Corporations are double taxed, so the taxes come in to the corporation, the government takes out taxes, and then the profits are distributed to the owners, and the government takes out taxes again. That's in contrast to LLCs, where revenue comes into the LLC, no taxes are taken out, profits are passed on to the owners, and then the taxes are taken out. So that double taxation for corporations is really crappy, as is the rigidity of the of governance, right? There's a lot more rules and laws about how corporations make decisions and are governed. Some people like that because it makes for more predictability. That's the reason why VCs, venture capital firms, and other funds like corporations. But the big reason why venture capitalists, private equity, big investment funds like corporations is because certain of their investors receive much better taxation on revenues that come from corporations than come from LLCs. And that is because the corporation is double taxed in that way. And so as a result, you really want the real reason why you would choose the main reason why you would choose a corporation over an LLC is because you are working with investors who insist on it for their own benefit. For their own benefit in terms of taxation mainly, but also their own benefit in terms of the governance rigidity. But other than that, general practice is to go with an LLC because you get more flexibility in governance, and you get much better tax treatment. You only get taxed once, and so on the exam, that's what you're looking for, right? Is what is what among these three factors? What are the client's immediate needs? Do they need to attract outside investment? Do they need to minimize? Their taxes? Do they need flexibility in their governance? And there's not really, I should add that there's not really a right answer. I mean, you have to kind of analyze each situation case by case. So, for example, if somebody's like, I have a venture capitalist, they insist that I form my company as a corporation, and they're going to invest tomorrow, that might be a reason to do it as a corporation. If you say, I think I'm going to get outside investment, and I think that those investors are going to want a corporation, but that might happen in 2 years. Set up as an LLC because it's not sure, it's not certain, and you don't. That's 2 years of not being double taxed. So this would make kind of a good, part of a good essay question, because it gives you the opportunity to kind of discuss, the pros and cons of each in this context. Okay, so that's sort of I think that's all the high points of the business entities section. Let's move into securities here so that we don't take up too much time. The big thing to remember about securities law generally is that after the Great Depression, the federal government said too many people are getting ripped off by shady, unregulated, unscrutinized companies. So all sales of securities in the United States, again, securities for these purposes are equity ownership interest in things like corporations and LLCs. All sales of securities have to be registered with the federal government and scrutinized on an ongoing basis, unless they fall under some narrow band of exceptions. So the general rule is that everything has to do basically an IPO, right? Everything has to go file a ton of stuff with the SEC and file quarterly reports with the SEC and open up their books to auditors and all this other highly onerous stuff. And that is the general rule. And even if you are opening a tiny barber shop on the corner and you're taking money from friends and family, in theory, you need to go register that sale of ownership interest in your barbershop, your aunts and uncles and cousins, with the Securities and Exchange Commission. Now, most people don't do that. And in fairness, many of them, without knowing that they're doing it, fall under one of the key exceptions. And the biggest exception is, and by the way, I'm not, as you know, I'm not a big fan of asking you guys to remember the exact names of these laws and rules, but, the Securities Act of 1933 is the Great Depression era rule that set that general requirement that every sale of securities gets registered. And then Regulation D under the Securities Act has the key exceptions. Know for the exam, just be able to spot and know what all these definitions are. There's a lot of sort of new terms that you may or may not be familiar with. There are 3 slides on them, 4 slides in the securities in the securities slides. What are securities? What is a private placement? What is general solicitation is an important one, right? Basically, can you go out and advertise publicly, hey, we're raising money by selling shares of our company, right? If you do that, or if you want to do that, the rules are very, very different. Generally speaking, if you refrain from advertising publicly, engaging what they call general solicitation, then you have a lot more options, and it's easier to meet one of these exceptions to the general requirement that you register and do a public offering. Know what blue sky laws are? Right, so know what securities are, know what private placements are, know what general solicitation is. You don't have to worry too much about restricted securities or broker-dealers. Know what blue sky laws are. Blue sky laws are state-by-state securities laws that apply, again, unless you fall under an exception. And as we'll see in a moment, not all federal exceptions get you out of compliance with the blue sky laws, with the state-by-state laws. And so, much like general solicitation, you want to keep an eye on what gets you out of the blue sky compliance with the state-by-state rules, because if you have to comply with the state-by-state rules, if you've gotten an exception at the federal level, but you still have to comply with the state-by-state rules, then you have a situation in which if you have investors from 25 different states, you have to make filings and make sure you're compliant in 25 different states. And it's a huge pain in the butt, and it costs a ton of money because you have to pay a bunch of different lawyers in a bunch of different states, and you want to avoid it. So keep an eye on that, right? Keep an eye on whether or not you can engage in general solicitation and whether or not you are required to comply with the state-by-state laws known as blue sky laws. Know what a private placement memorandum is? Just generally, it's a very onerous, highly detailed document that you have to provide to investors under certain circumstances that adds time and money and risk to your equity raise. It's similar, you can think of the private placement memorandum as being basically the equivalent to the kind of information that you need to provide in an initial public offering, right? In other words, if you've gotten out of if you're trying to avoid the burden of disclosure that comes with a public offering, with registering with the SEC and doing a public offering, you're losing a lot of that advantage if you also have to provide a private placement memorandum. And then perhaps most importantly in the real world, and therefore most importantly for this exam, you want to know who qualifies as an accredited investor. There's a slide on this in the notes, in the slides on securities, and it's very important because whether or not you are offering your securities and selling your securities to accredited investors only, accredited investors and some number of non-accredited investors, will make a huge difference in what you have to do to comply with the securities laws. And the definition of accredited investors is a long one, but the important thing to remember are basically these four, I would say. Somebody who has a net worth in excess of $1 million, excluding the value of their primary residence, right? So if I have a net worth, as you know, is the value of your assets minus the value of your debts. So let's say I have no debt. I wish. My house is worth $1.2 million, and I have $100,000 in the bank. My net worth is $1.3 million, and I'm not an accredited investor because you have to subtract the value of the value of my primary residence from the net worth equation. Does that make sense? And I think that would make like a good true-false question, actually. You are also an accredited investor if you have had income over $200,000 annually in each of the 2 most recent years and reasonably expect to make the same income level this year. So if I made, it's 2018. If I made $200,000 in 2016, $200,000 in 2017, and I think I'm going to make at least $200,000 in 2018, then I'm an accredited investor for the purposes of the securities laws. If I made $100,000 2016, $200,000 2017, and think I'm going to make $500,000 this year, I'm still not an accredited investor because of that $100,000 in 2016. If I made $500,000 in 2016, $400,000 in 2017, but then quit my job to invest in securities, and I don't know what my income's going to be this year, I'm not an accredited investor under this definition. Now, I am if I have a net worth that exceeds $1 million. You're an accredited investor for the purposes of a specific company if you are a director, executive officer, or partner of a company selling the securities. So these rich people, the $1 million people, the $200,000 in income, they can invest as accredited investors in any private offering. But this little loophole exists to make sure that if I am an officer or director of a startup, say, I can invest in that company as an accredited investor because I know a lot about it, right? And it would be weird to say you are busting your butt to grow this startup, but you can't invest in it because you're not an accredited investor. You're not rich enough. That would be sort of weird. So the law has created this exception, but note that these guys can't invest in, I can invest in my company as an accredited investor, but I can't invest in yours unless I meet one of these rich guy accredited investors definitions. Okay. So then there are all these the actual specific exemptions under Regulation D. And they're a pain in the butt. They're very important. And I will be completely honest, I often have to look them up myself just to remind myself what the specifics are. And there's a lot of them, but I've provided you guys, and we talked about in class, the 3 most common. Actually, 2 most common and 1 that's new and a little weird, and nobody knows what's going to happen with it yet. So Rule 504, again, I'm not going to ask you what does Rule 504 let you do. What I'm going to do is I would give you a scenario, and then you would have to know basically what you're allowed to do under that scenario. If you can tell me this rule, you're allowed to do X, Y, and Z under Rule 504. Great, but you don't have to. Rule 504 has a cap of $5 million. If you're relying on Rule 504 for your exception to the general rule that all security sales of securities have to be registered, you're limited to raising $5 million in a 12-month period. You can sell to accredited and unaccredited investors. You can't engage in general solicitation. You don't have to provide detailed information to your non-accredited or accredited investors, but you have to comply with the state-by-state blue sky laws. And that's the reason why people don't generally use this Rule 504 exception, because that state-by-state blue sky stuff is a pain in the butt. It increases your costs. It slows things down. It creates more liability because each state can now nab you for doing something wrong under their laws. And the other reason is that there's that cap of $5 million, although, for most startups, $5 million is a pretty good chunk of change. The most common rule that people use as an exception to the general requirement that you register and do a public offering is Rule 506B. It lets you raise an unlimited amount of money, and you can sell to as many unaccredited investors as you want, but you cannot sell to any more than 35 non-accredited investors. If you sell to 36 accredited investors, you are going to have to rely on Rule 504 or do a private offering. To qualify under Rule 506B, you can engage in general solicitation. You have to provide, if you have even one, this is important, if you have even one non-accredited, if you have 300 rich accredited investors and one non-accredited investor, you have to provide a PPN. You have to do the big disclosure document. And honestly, at that point, you might as well just do an IPO for the most part. And so in practice, people tend to rely on Rule 506B, don't sell to any non-accredited investors, so they only sell to accredited investors, and that way they can get the benefits of Rule 506B without having to provide a PPM, all that extra disclosure. So to finish out the main points for Rule 506B, unlimited amount of money, unlimited number of accredited investors, no more than 35 non-accredited investors. You can't engage in general solicitation. You have to, if you have any non-accredited investors, they have to be financially sophisticated. You have to provide them with a PPM, as I just said. But you do not need to go out and dig into their tax returns or get really nosy to make sure that they are accredited investors. Make sure they meet one of those requirements. And the other big thing about Rule 506B, which is great, and it stands in stark contrast to Rule 504, is that you don't have to comply with all the state-by-state securities laws. You have to make a Form D filing with the SEC. It's like a one-page thing. And you have to make a similar filing with all the states, but you don't have to comply with the actual state-by-state laws. And that's a huge benefit of Rule 506B. And if you can do 506B and sell your securities to 0 unaccredited investors, all the better, because now you don't have to provide all that extra information. And then real quickly, Rule 506C, which is relatively new, was created in the Obama administration under the Jobs Act, says that you can raise an unlimited amount of money and you can do general solicitation. You can set up a website geared towards accredited investors, because that's the other big thing about Rule 506C. You can only sell to accredited investors under Rule 506C, and you have to confirm their accredited investor status, right? You can't, unlike 506B, you can't be like, hey, you're accredited? Okay, cool. You're in. Under Rule 506C, before you sell the securities to somebody, you need, and there's a list, and we don't have to get into it, but you need to look and see their tax returns, talk to their accountant, talk to their lawyer, get a signed letter from their accountant and their lawyer saying that they meet the requirements of an accredited investor. That is very invasive, and so people haven't really used this a lot. But it's new, and we'll see how it pans out. And so this would basically be like Kickstarter, but instead of offering some kind, a good, sample of one of your goods from your new startup, you're actually selling ownership interest in the company. But you can only do it to an accredited investors, and you have to confirm their accredited investor status. It does let you preempt or bypass the blue sky laws, but you still have to file Form D with SEC and similar minimal state notices with each state where you have investors. Okay. Moving on to intellectual property. Looks like I've got a question coming in, so I'll wait. Come on, Macy. Come on. Just kidding. No? No question? All right. Hold on. It's there's a question: is it a PPM as in Michael or a PPN as in Nancy? It's a PPM as in Michael. Stands for Private Placement Memorandum. It's not really an official defined term, but it's what everybody, including the SEC, calls the big old disclosure document that you are sometimes required to file under these rules. Macy, you're asking, can you not rejoin a call after leaving? I can't imagine that you wouldn't be able to. Why? Is somebody trying to dial back in? There's also a link. You can just click on a link and get back in. Yeah, exactly. So if you find the email that I sent around, click on the link. That should get you back in. Okay, so moving on to intellectual property, we did, as you know, a very whirlwind tour of intellectual property law. By the way, I think this is going to be helpful for you guys for the exam because there's a lot less material, right? We covered a lot of this stuff pretty quickly, in part because I went to Mexico. And so there's just it's pretty basic. Like the introduction I gave you guys is fairly basic. For better or worse, all right, so Macy, I guess I'm confused because you're here, you're typing. Can you not hear or see us? I guess not. Sorry guys. Yeah, this is the reason why this is actually working a lot better than I thought. But there's always, in technology, always some weird thing with technology. just trying to see if it's really weird. Okay, I mean, unfortunately, I think I have to keep going because, I know everybody has got, oh, Carly, you're a freaking genius. You're my hero, Carly. Yeah. So yeah, I had to. Okay. Yeah. So I think that saves us, Carly. Thank you so much. Sang was saying that I should buy her lunch later. I mean, Carly, you did leave your potential bomb and/or drug package in the classroom, and I carried it around in my car without opening it for like 3 days. Oh, that's nasty. That's so nasty. I would say, but here's the thing, Carly. Like, if you are on the edge of like an 89 and a 90, I would probably take this into consideration. All right, let's keep going. Thank you again, Carly. Like I said, I really appreciate it. I can make no promises, but you may well benefit from your generosity and your foresight. Okay. Intellectual property. Okay, let me see. So intellectual property, we covered 3 main things, right? Patents, trademarks, and copyright. And to a lesser extent, trade secrets, transfers, and licenses. Forget about transfers and licenses for the purposes of the exam, because they are what they are, right? They're the rights to buy or use somebody else's intellectual property. I just want you guys to know that they exist, but you don't have to worry about too much for the exam. For the exam, it's important to know when you are talking about each one of these different 3 main types of intellectual property or IP. People will say, well, I need to patent my trademark name so I can have a copyright on it. It's like, no, those are 3 different things. I don't care just for semantics purposes. The real world repercussions of these 3 things are pretty important. For one thing, if you really want to trademark your barbershop's name or logo, and you go try to register a patent, you're going to get very frustrated. You might spend a bunch of money unnecessarily. So knowing the basic difference between the 3, I'm going to add trade secrets in there as well. Between the 4 is very important. So, really briefly, patents protect inventions. Trademarks protect brand names. And copyright protects creative works, let's say. And then trade secrets protects secrets. I'm going to cover patents and trade secrets quickly and together for reasons that will become clear shortly. So again, patents protect an invention. If you have a new and non-obvious invention, and you file a patent, and you file a patent application, the patent application, utility patent application is granted, you get 20 years where you have the exclusive right to commercially exploit or use that invention. The idea, of course, being that you are incentivized to go out and make a bunch of great inventions that will benefit humanity if you have 20 years to make a bunch of money off of that invention. Again, it's 20 years, and it applies to everything from machines, products, chemical formulations like drugs, computer software, some kinds of plants and crops. That's a utility patent. A design patent covers the ornamental design of an object that has practical utility. So if I invent a really cool looking broom, this actually happened with in my real life. Somebody said, "Oh, I want to patent a new broom." It's like, well, I'm not a patent lawyer, but a broom is neither new nor non-obvious. The best he could probably do is get a design patent that would protect the design of his broom for 15 years. The problem with that is you make a slight alteration to the design, and you're not infringing on the patent. But anyway, so when people talk about patents, they're usually talking about utility patents. Now, notice that something that is very that is inherent in patents is that you are disclosing your invention publicly, right? We can go right now on Google and go to Google Patents and review all the patent applications and patents that have been issued in the United States, and I think the EU. It'll have drawings of the inventions, or if it's, let's say it's a drug, it'll have detailed chemical information and analysis about the chemical invention, the pharmaceutical invention, meaning that anybody out there with the know-how can copy your patent. The reason that what is stopping them is the law of patents. If you have an invention and you don't want to make it public, you can opt to keep it as a trade secret instead. And this is what Coca-Cola has done. It kind of blows my mind that Coca-Cola, that modern technology doesn't allow people to reverse engineer and figure out what's in Coca-Cola, but whatever. Your trade secrets, if you have something that is not patentable, or if you have something that is patentable but you don't want to disclose it to anybody else, you can choose to maintain it as a trade secret, and that's not limited to 20 years. That's as long as you keep it secret and take proactive steps to keep it secret. You can take advantage of that invention or other kind of secret forever and ever. You can sue people under various laws, Economic Espionage Act. There's a number of other ones, and so you can protect your secrets that way. Again, patents got to be made public. Give you 20 years. Trade secrets don't need to be made public and are unlimited in terms of the term of the time period of protection, so long as you maintain the secret as a secret by using NDAs and locking the secrets away, not telling it to all your employees, so on. Okay. Trademarks. A trademark is some kind of visual, usually visual, but sometimes can be things like sounds and smells. So some kind of mark that is associated with your product or your service. And it's such that the consumer associates your product or service with that mark. It can be, Apple computer. The name Apple, in association with computers, we think, we know if I talk about an Apple computer versus a Dell computer, you know which product I'm talking about. If you see the Apple computer logo without any words, you know what products that logo is associated with. If you see the Windows logo, you know which product that's associated with, even though it doesn't say Windows. Those are all trademarks. Service marks, same thing, but they are associated with a service rather than a product. So if I have a lemonade stand, I sell lemonade, then my trademark is, or trademarks, plural, are associated with my product, the lemonade. If I have a lawn mowing company, my marks are associated with the service of mowing lawns. So it's a service mark. Whatever. People just call them trademarks for the most part. Know that they are that they accrue by common law, right? So if you go out and use a mark with a good or a service, you have certain rights in that mark, but your rights get much stronger and they are easier to enforce if you register the mark with the U.S. Patent and Trademark Office, and that's the difference between the little TM and the R in a circle. TM says, hey, world, I am asserting that this is a trademark that I have common law rights in, whereas the little R says, hey, world, I've registered this with the federal government, and don't copy it, don't infringe on it. Speaking of infringement, the infringement standard, it's a complicated area of law, but the basic question is whether the average consumer, the reasonable consumer, would be confused about the source of the goods or services. So if I start a computer company and I put an apple on it, or maybe even a pear with a bite out of it, then Apple's going to sue me, and they're going to say the average consumer might well think that is, might get confused and think that mark is associated with my products, not your products. However, if I start a airplane company, I make airplanes, and I call it Apple Airplanes, and I stick an apple on there, it's a completely different industry, so the average consumer is probably not going to be confused. They're going to be like, that's a different company, a different product, doesn't come from Steve Jobs' company, Apple Computer. So if the industry is different enough, the likelihood of confusion goes down. Or if the mark is different enough, right? If it's, instead of, I call my company, let's say it's based in Pearland, Texas, and I call it Pearland Computer, has the word pear in it, pear's a fruit, apple's a fruit. But like, the average consumer is not going to, they're going to see Pearland and be like, that's obviously not Apple Computer, it's a different company. So that's arguably not going to be infringing. That's the basic standard. Finally, copyright governs or protects what they call original works of authorship. Which is a very accurate description. I say creative works, although that's not as accurate, right? Because whoever designed the Apple logo created a creative work, and in fact would have copyright rights in that work, but it's really more of a trademark. But copyright is going to cover things like books, poems, artworks, plays, musical compositions, architectural designs, so on and so forth. So if I write a play, I have copyright in the play itself, the intangible play. So you can't copy the, whatever you call it, the script of the play. I forget what that's called, play book or whatever it is. But you also can't film it because you are reproducing and infringing on my rights in my creative work, which is this play that I've written. Like trademark, it accrues the minute, if I write a book and I publish it, then I have copyright in that book. It accrues from the moment that I put it in have fixed it in a tangible form. But I can have stronger rights if I register it with the Library of Congress, who has a copyright office. It's done online. But note for the exam that if I just have notes for a novel, and I'm still working on the novel, and somebody sees those notes and copies my novel idea, I can't sue them for copyright because I haven't fixed my novel in a tangible form. It's not finalized in a printed form, right? It's just notes, it's a work in progress. So the common law copyright doesn't begin to accrue until it's fixed in a tangible form. Tangible form might be printed, it might be, it might be a video, but it is tangible. You can see it. It's clear what the boundaries of my creative work is. Trade secrets we've discussed. Transfers and licenses we don't have to discuss. Finally, agency. agency, will like I said, there will be 10 questions on it on the exam, but they will not be terribly difficult, just because we didn't cover agency in great detail. But remember that there is that agency law governs relationships where you have somebody acting on behalf of another person. The person doing the acting is the agent. The person on whose behalf they're acting is the principal. And then there are third parties out there in the world who they may deal with. So, hold on a second. And I drew sort of a triangle on the whiteboard in class, and you had principal, and you had agent, and you had third party. And the reason I drew that triangle is because between those three people, keep track of who owes what responsibilities to other rights and responsibilities to other people. This is all sort of abstract, so let me give you an example. I mean, the question is, if I run a business, whatever, let's go back to my ice cream store. If I run a business and you're my agent, that might mean you're my employee or contractor. It might just mean agency principal law can be created just because, and we'll talk about this in a second, just because you came into my store, you're my friend, and I send you out to do a task for me, then you're my agent. I'm not necessarily paying you, we don't have a signed contract, whatever, but you're my agent, you're acting on my behalf. Okay. So the question then becomes, you are my friend, you come into my store and I say, hey, student, could you run out and buy 500 gallons of milk because I need some for my ice cream shop, and you go out and you do that, under what, and something goes wrong with that transaction with a third party, the milk vendor, what rights and responsibilities do you have to the milk vendor? What rights and responsibilities do I have to the milk vendor? What rights and responsibilities do I have to you? That is sort of the essence of agency law. Like I said, this can come up in a lot of contexts. We didn't cover employment law in this class, but this underlies a lot of employment law. Agency law underlies a lot of employment law. It exists where you have an attorney-client relationship. It exists where you have an investor and a portfolio manager, an investment manager. Obviously, it exists and comes into play with employers and employees. Can come into play if you have a modeling agency or a talent agency, and the talent's agent, right? You go to Hollywood, you want to be a big star, you get an agent, that agent is acting on your behalf. And you probably have, I hope you have a signed contract with that person, but even if you didn't, if that person is authorized to act on your behalf and in fact does so, that person is your agent for the purposes of agency law. So what kind of liability these parties have to each other will depend on whether or not they have actual authority or apparent authority. Actual authority is where it is set. It's, let's go back to the ice cream shop. You come into my shop and I say, hey, student, can you do me a huge favor and go out to the milk vendor and get 500 gallons of ice cream? Yes, you're acting on my behalf. Go do it on my behalf. I have expressed to you that you have this authority. You are my express agent. Contrast that with if you are, you're my employee, and one of your jobs is to go out and get ingredients for the ice cream, right? I'm there making the ice cream, and I don't have time to go out to pick up the strawberries, pick up the milk, pick up whatever, and you go out and go buy the milk. I didn't say, hey, you are my agent for the purposes of going out and buying this milk. But it is implied in the scope of your work and our relationship that you have the authority, the actual authority, to go out and buy the milk. Okay, that's actual authority. Apparent authority is where my words or conduct would lead a reasonable person, a third party in the milk vendor's position, to think that you are authorized to act on my behalf. So let's say you're not my employee. I didn't say to you or to the milk vendor, hey, student's my agent's going to come by and pick up the milk. But one time when we were both happened to be in the dairy farm, I said, student this is my best student. Trust him with my business. Trust him with my life. I'd let him do anything. I'd let him do anything for my ice cream business. I have now created a situation where you have apparent authority, and the third party can rely on that. If you show up and buy 500 gallons of milk on my behalf. But this, in any hypothetical on the exam where there's a grant of, or so you spot that there might be a grant of agency, keep an eye on whether it's actual authority or apparent authority. I'm going to try to make it as clear as possible without coming out and saying it, because whether the agent's authority is actual or apparent will have a huge impact on what kind of liability the agent has. So if the agent has actual or apparent authority, so you have to look at whether or not they have actual or apparent authority. You also have to look at whether or not the authority has been the identity of the principal has been disclosed. So if the agent has any kind of authority and the identity of the principal and the relationship of the principal has been disclosed to the third party, then the agent has no liability for their acts within the scope of their authority. Real world example. Okay. You go to the dairy and you say, hey, I'm buying this milk for Michael's ice cream shop. So long as you have actual or apparent authority, we've talked about what those scenarios might look like in this hypothetical. If the contract, if I don't pay the contract, I don't pay for the milk, the dairy cannot sue you. You are my agent, and you disclosed the relationship to the third party. So they cannot sue you. They can only sue me for the value of the milk. If the relationship is undisclosed, you don't tell them. You show up. You have apparent authority or actual authority based on you and me having a discussion. But you show up and you don't disclose our relationship to the dairy farm. And I don't pay for the milk. They can sue you and they can sue me. They can sue the agent or the principal. Now, if you go to the dairy farm and you have neither actual nor apparent authority, I have not given the third party any reason to believe that you act on my behalf. And I have not told you that you act on my behalf, and you don't have a job with me that implies that you act on my behalf, and you go to the dairy farm and sign on my behalf, I can sue you. If the dairy farm sues me, I can sue you. And you have to basically reimburse me for any damages. Notice that that's not the case if you do have apparent authority. If you do have apparent authority, I'm liable. I'm on the hook and I can't come after you. I can only come after you if you acted outside of the scope of your authority, whether actual or apparent. That's the big one, right? This slide of liability of agent to third party is the big one. It's the big conundrum in agency law. Just real quickly, the agent has why I told you this, that the agent has acted without actual authority. They have to indemnify the principal for any damages that the principal incurred as a result of the agent's action. So if, real world example, stick with the ice cream hypothetical, you go out and buy a bunch of fireworks for the ice cream company, and I get sued by the fireworks company because we don't pay for the fireworks. I say, we're an ice cream company, we're not a fireworks company. I never told you could go, I never told you could go buy fireworks, nor is that apparent from the scope of your work for me. Now I've been sued. I can sue you as the agent for whatever damages I sustain from the lawsuit from the fireworks company. If you have actual authority, not apparent authority, but actual authority, and you incur reasonable costs carrying out your tasks, driving out to the dairy farm, or flying to a meeting, whatever, I have to reimburse you for those costs. Even if we don't have a contract saying so. And then you have a number of duties. Once you become my agent, you have a number of duties to me. Fiduciary duties, right? You can't go help another ice cream company without my approval, right? You can't accept new obligations that are inconsistent with your duties that you owe to me. And you can't usurp opportunities. You can't go out and compete with me, basically, or help somebody else compete with me. Again, this rule exists as a result of agency law, and it exists even if we don't have a contract or a non-compete. Because you are my agent, you owe me these duties. The only thing I owe to you is that I have to fulfill any contractual obligations I have to you, whether it's to pay you or whatever, pay you an ice cream, whatever. I have to provide you with all the information you need in order to carry out the tasks, right? So, if the dairy farmer is a nasty character and he requires you to call before going to pick up the milk, or he'll shoot at you, I got to tell you that because it's important to you carrying out your duties. And that's all I've got on agency law. I think that will be a fairly easy section with really sort of one-dimensional hypotheticals, just because we didn't have time to go into it in any great detail. So that is what the multiple choice section is going to be about. It is going to be 40 questions, 10 on business entities, 10 on securities, 10 on intellectual property, and 10 on agency. Within each of those 10 questions, there will be 5 multiple choice questions, 5 true-false questions. There will be 5 bonus questions that can only help, not hurt you. They will be taken from previous exams. They'll be comprehensive. But again, you think you got the first 40 down pat, you could answer not a single one of the bonus questions, you would still get 100 on the exam. The bonus questions, I'm going to try to make them hard because they were way too easy last time. But they won't be, they will come from previous exams, so they won't be completely out of the blue. So that is the multiple choice part. The multiple choice part is going to be 70%. Sorry, that's not true. Let me double check. The multiple choice section of the exam will be hold on. What is it? Question is, do you have to bring blue books on your own? No, fortunately this department, finance and economics, gives us blue books, so I will bring blue books. Finally. Okay, there's one I'm looking for. Okay, so the multiple choice section of the exam is 75% of the grade, the final grade, and then the essay portion is 25%. And for the essay question, again, just to emphasize, the 75% multiple choice part covers only the last quarter of the materials from the class, i.e. the stuff we just talked about. The 25% essay part is comprehensive, and I'm going to give you 3 different hypotheticals. And they're going to look a lot like, for those of you who looked at the extra credit stuff, they're going to look a lot like that, but they're going to be a little bit more detailed and I think a little bit more difficult. And it's basically going to be a real-world scenario that raises a number of questions from the materials throughout the class. It might, the hypothetical might have a contracts issue, a contracts dispute that touches on dispute resolution questions, right? Going all the way back to is it state court or federal court? Do we do arbitration or do we go to court? And it might also touch on business entities, right? Hey, is this contract signed? Who's liable for for the damages? If here's a contract dispute. Are we going to win the contract dispute? Is it going to be in state or federal court? And if we lose, whose assets can they come after? Mine, my personal assets, or only the company's assets? That kind of a thing where you're having to look at the scenario in the context of a number of different, through the number of different lenses, quote unquote, that we've discussed in this course. I don't think they're going to be super easy, but I think they're 25% of the grade, so they're a smaller portion of the grade, and they're open book. The multiple choice part is closed book, and we're going to do that, and then once everybody's done with the multiple choice part, and I'll probably give you an hour for that. If you guys want to. You finish and if you finish in 15 minutes and you give me your Scantron, you can go do whatever you want. I don't care because you can no longer cheat because the second half of the exam is open book. So you can come back, or if once I've gotten all the Scantrons, you guys can do whatever you want. Bring out your notes, bring out your computers, bring out Google. I don't care. What I care about is your ability to spot issues in a set of facts, and then apply the law that we've talked about to those facts. Does that make sense? So yeah, that's the format of the exam. And I guess rather than go over all of I can't go over everything that we covered in the whole semester, all whatever it is, 12 sections, and really it's more than 12 because contracts was huge. If you guys have any questions, I'm happy to take them. I think that the things, dispute resolution will be important. Dispute resolution is going to show up somewhere in these hypotheticals. Oh, you can choose one of the 3, by the way, right? So I'm going to give you 3. Each one will cover a number of areas, but you can choose the one that you like the most. Dispute resolution is going to show up in one, if not all of those hypotheticals. Contracts will show up in one, if not all of those hypotheticals. Torts is likely to show up. Securities is likely to show up. Business entities are likely to show up, although you will have just studied those. But international law may make an appearance, a small appearance in one of the hypotheticals. Privacy and cybersecurity might make a small appearance in one of the hypotheticals. Con law, same thing. But if I were you and I had the time, I would go over at least dispute resolution, torts, and contracts. And again, contracts is huge. But I would at least read through those slides just so you're familiar of where to find what, right? And you should also be well organized, right? Like if I were you, I would download all of the slides and then have them either printed out, although printed out would be a massive document, or somewhere on your iPad or your computer, whatever. And so you can at least say, okay, this hypothetical covers There's a con law issue, there's an international law issue, there's a torts issue, and a contracts issue. Boom, boom, boom. I'm going to be able to find those really quick, and I'm going to, and then I can use those materials to write my essay. I would ask, I may even send out an email to this effect. Being very organized in your essay will help a lot, right? Short answer. Boom, boom, boom. Here are the 4 issues. Here are my 4 conclusions. And then detail as to why. The detail is important because one of the things that I've been noticing in some of the extra credit assignments is that people will say, yes, you can do that because you have a contract. No, you can't do that because there's a debt. And it's like, well, I need to know what legal principles that we've discussed apply to these facts and how they apply. Right? So I can't give you some of you guys, I haven't been able to give you guys full credit for some of the extra credit stuff because you've just sort of alluded generally to an answer, but I want to see that you know the specific legal principles, you know the legal the legal lingo, and you apply it to the facts. And that'll be very important for this essay portion. I've got a question about arbitration. When would arbitration be preferred? So the main thing to keep in mind when it comes to arbitration is that it's optional, right? You can't force somebody to go to arbitration. They have to agree to go to arbitration either at the time or in a contract or an agreement that you had beforehand, right? So if we draw up a contract and it says nothing about arbitration, and then we decide, and then we have a dispute over the contract, you can't force me to go to arbitration. We can say, hey, we don't want to deal with the expense and hassle of litigation, so let's agree to go to arbitration. Alternatively, if we draw up the contract, we can have an arbitration clause that says all disputes arising out of this contract will be decided in arbitration, and you can even get much more detailed and say arbitration by this arbitral company, because there are companies that do it, nonprofits, with this many arbitrators, the arbitrators have to come from such and such background and so on. The other important thing to keep in mind about arbitration is that it is binding. In the United States and in most other places, if you agree to go to arbitration and the arbitrator makes a decision like a judge would, that is binding. And if the parties don't abide by that award, then you can go to court and have that award enforced, and the court's not going to second guess or double check the arbitrator's decision for the most part. So when would you want to go to arbitration? You're negotiating with another party, and they say, hey, let's put an arbitration clause in our contract. When would you want to do that? You'd want to do it where you are concerned about costs. Arbitration tends to be much less expensive than litigation. It tends to be, because it's a more streamlined process. It takes less time. There are less opportunities to file motions that delay or add to the process. And so that's a big reason why people like to do it. Also, the courts are really packed. The courts have a huge backlog of litigation. We're a very litigious society. And if you do arbitration, your dispute will be heard. You're paying the arbitrator. The dispute will be heard right away, very quickly. So managing costs, keeping time down, those are reasons to use arbitration. Another reason is that the arbitrator doesn't need to be a lawyer or a judge. You can say in your arbitration clause, you can say, hey, we're in the construction business, so we want the arbitrator to be somebody who has experience in the construction industry. Or you can say, we want 3 arbitrators, one of whom is a lawyer, one of whom is a construction industry expert, and the third is somebody appointed by those 2 arbitrators. In other words, you can kind of custom pick your trial of fact and your judge, right? You can say, we want it to be this many judges, and we want them to have this background. And that's great because if you're in an industry like construction or the computer industry or the software industry, where there's a lot of technical industry knowledge, and you go to litigation in courts, you might get a judge who's some old 90 or 80-year-old judge who has never turned on a computer. And if the dispute is likely to turn on very technical questions of software engineering, you're like, well, crap, this guy has no idea what's going on. If we had agreed to go to arbitration, we could ensure that we had a software expert on the arbitral panel. So then the question comes up, why doesn't everybody do arbitration? Well, one is because arbitrators don't have as much power to issue things like preliminary injunctions, right? They can do it, but then they can't, an arbitrator can't hold you in contempt. So an arbitrator can say, hey, stop doing that. Let's say it's a construction dispute, and I want you to, I know that if things go wrong in our construction contract, I'm going to want to be able to order you to stop construction. And if we choose arbitration, we have to go to arbitration, set up the arbitration. That takes some time. Once it gets going, it's really fast, but setting it up takes some time. And then I say, hey, arbitrator, tell him to stop doing it. The arbitrator says stop doing it. We're still going to have to go to court to enforce that. And so injunctive relief is more difficult with arbitration. So if things are if you really want to be able to tell somebody to stop doing something or force them to do it, you want to go to court as opposed to arbitration. That's sort of the big reason. I really like arbitration. So it's hard for me to say. I guess another reason to avoid arbitration is what I just mentioned: the setup time. With court, you go in. If you say that it's super urgent, and you go to court and you file a lawsuit, and you can demonstrate the urgency, the court's going to draw its attention to your case pretty quickly, or at least that issue that is urgent. Whereas with arbitration, you got to go file with the arbitration entity. Maybe you have to choose one if you haven't specified one in the contract, so you argue about that. Things like that. It can be a little bit slower in the beginning for arbitration. And you don't have people who are super well versed in the law, whereas judges are experts in the law. They might not be experts in software, but if you think your dispute is going to turn on questions of law rather than questions of facts surrounding software, you might prefer a judge because they're arguably smarter when it comes to the law. Any other questions? I think so there's a question, can you say how the MC portion will be set up? Multiple choice portion, yeah. Okay, so there's going to be 45 questions on the multiple choice portion. 5 of those questions will be extra credit. They can only help you, can't hurt you. In other words, even if you don't know what the heck they're saying, just guess. So that's 5 are extra credit. That leaves 40. And the extra credit questions will be pulled from past exams. They'll be comprehensive and they'll be pulled from the previous 3 exams. 40 questions on these last 4 topics that we've covered since the last exam. That's business entities, securities, intellectual property, and agency. 10 questions on each of those topics, 5 multiple choice, 5 true false. That makes sense? Got a question about the extra credits. So I haven't even sent around the last 2 extra credits. I sent around the optional 4th quiz. And Carly, if you're still on the line, you are the reason why I'm doing 2 extra credits on top of the optional quiz, because you said, correctly that since I promised that there would be two additional extra credits rather than one, I'm going to send those out. I'm going to send them out. I still got to finish writing this exam, so I'm not going to send them out today, and you guys probably wouldn't do them today anyway. They will be due. That's a good question. So the final grades are due. Let me see. Dang it. Okay. I'm going to say that they're going to be due on the 11th. The 11th is the last day for makeup exams. So let's say that they will be due on the 11th. I'll obviously give that date in the email when I send out the extra credits after the exam. But the 11th is next Friday, and the exam is tomorrow. So that gives you a week and a day. I know this isn't your only class, but that gives you a week and a day to do the extra credits. Any other questions? Carly, if you could just upload the video that you took either to Dropbox or whatever. I think that's gonna be easier than emailing it to me because I think it's gonna be a huge file. But whatever, you can probably figure that out. If you can't, though, just shoot me an email and we'll work out some way to get that video up for everybody to see. And again, thank you very, very much for that. Got one more question coming in. Do you guys like my home office? I had to make sure there wasn't anything embarrassing back here. I don't know what that would have been. That's not true. I moved a book. That has about Renaissance art, and it had some nudity in it, and I moved it. So there. So Carly's saying that she's going to send an email out with her number on it, and whoever wants it, they can text her because the file might be too big. Yeah, I think that's totally fine. I mean, Carly, we can connect kind of offline. There should be, the way I've been doing it is uploading it like to YouTube, but I don't know, but it's a pain. I don't know how to tell you how to do it because it's always kind of a trial and error thing for me as well. So don't send your number to everybody. That's creepy. Why don't you just have people email you? Like, do you want, or email me? I'll just tell people to email me, and then people who want the video can I'll put you in touch with them. Okay. One more question, and then I think we're probably done, unless there's any other pressing issues. And I can go eat breakfast, which I forgot to do this morning. Well, that's the question I just answered, Stefan. Arbitration. You mean mediation? Yeah, okay. Mediation is like arbitration, but it's non-binding. That's the big difference. Mediation is, there's a dispute, and rather than sue each other, we're going to agree, same thing, you can agree beforehand in your contract, or you can agree at the time of the dispute. We're going to go to mediation, and mediation is a little bit like couples therapy. You go, you talk, the mediator talks to both sides independently, talks to both sides together, and then comes up with a proposal and says, why don't, how do you guys want to resolve this? I suggest that you do X, Y, and Z, and the parties can settle it that way. But the mediator doesn't have the power of the arbitrator, which is to say, the mediator can say, you are wrong, you are right, you have to pay him $500,000. And then if the person doesn't pay the $500,000, then the other party can go to court and say, hey, Your Honor, we have an arbitral award for $500,000, make them pay it. And then the judge will be like, pay the $500,000, or I'm going to seize the property, or I'm going to throw you in jail for contempt or whatever. There's a question about whether this is if this is the same thing as civil cases, and it's not, right? A civil case is a non-criminal case, right? There's essentially two kinds of litigation: civil litigation, criminal litigation. criminal litigation, you committed a crime against society as a whole, and as a result, you are subject to the criminal law and criminal procedure and all those things before a judge empowered to try criminal cases, which we don't have to get into that. But in a civil case is a private case where you haven't committed something that is considered a crime. You haven't committed something that is considered an offense against society as a whole. You have a private dispute with another citizen, another person. Could be a contract dispute, could be a tort. Right? Those are the big ones, contract disputes and torts. Could be an agency law issue, right? It's not a crime, it's an agency law issue. Those are going to be civil cases that are before a judge. But you could choose to take any of those private disputes before a mediator or an arbitrator. Now, of course, a criminal, go out and murder somebody, you don't say, Your Honor, I'd like to take this to arbitration or mediation so that me and the prosecutor can come up with no. That's not an option in criminal cases, but it is an option in civil cases. So I don't know if that answers your question. Mediation is not the same as the civil case, but mediation and arbitration are optional dispute resolution mechanisms that you can use in civil cases. They are not available to you, obviously, in a criminal case. All right? Okay, guys. Any other questions come up between now and the exam, shoot me an email. I'll be happy to answer it. But other than that, best of luck, and I will see you tomorrow. Sangu says pie. I don't understand. Will I be bringing pie? No.